Number one. Yes, Gary. There is some typographical error in the order number. That is why this has been listed. This writ petition has been listed at our instance as some typographical error in the order dated 8/8/2023 with regard to the memo number of the impugned order dated 25/7/2023 issued by the DC District Magistrate, Capital Complex Itanagar, was brought to our notice after the order dated 8/8/23 was signed by us. Stop. There are Mr. T. Gyadi, learned counsel for the petitioner, and Mr. S. Tapin, learned senior government advocate, are present. The typographical error that has occurred in the order dated 8/8/2023 is the following. The order challenged in the writ petition is dated 25/7/2023, issued by the DC District Magistrate, Capital Complex Itanagar, by number DM/ICC/APU/01/2023-35. Semicolon, where is comma? In the order dated 8/8/23, it was incorrectly recorded as number NO/DM/JUD-01/2023. Stop. Paragraph. In view of the above, we provide that, henceforth, the order dated 8/8/23 shall be read as under. Then you type out this corrected version.
May Your Lordship, I beg to mention item number 11, Your Lordship. Here, the respondent has filed, respondent number 2, 3, and 4 has filed their counter affidavit. So, 4 weeks time may be granted for filing rejoinder. Item number 11.
Just a moment. Item number?
Item number 11, Your Lordship. Respondent number 2, 3, and 4 has filed their counter affidavit.
Yes.
So 4 weeks time may be granted for filing rejoinder.
Yeah, who is appearing for the government? 4 weeks is okay. Okay. The prayer of Ms. N. When it counsel for the petitioner, this is after 4 weeks for filing of the rejoinder to the counter affidavit filed by the state.
Obliged.
Yeah. I would like to mention item number 2, 8, and 9.
2, 8, and 9. What
Yes.
is 2?
This leading counsel, Mr. J. is suffering from one of the eye problem, conjunctivitis virus.
No, what is this matter about?
I don't know.
Huh?
I have no idea.
Pending.
Then,
Bills, they are claiming some pending bills.
pending bill.
Yes.
You have to wait. This is 2016 matter.
Next week, because the leading counsel has a problem, medical.
Let us have a look at the record. One more will assist. If you have paid the money, we'll close it. If you have not paid the money, we'll see whether you are entitled, the petitioner is entitled to the money he is asking for under the writ jurisdiction. 2016 matter. Yes.
Here, madam, we have filed our affidavit, but they have to file rejoinder also.
That's why you argue the case when it is called up. It is 8 years old matter, huh? No. 16, 17, 18, 19, 20, 21, 20, 27 years. Sufficiently old.
No, 8 and 9, Malad. Item
Yes.
number 8 and 9.
29.
Yes. After a week. Malad.
Why after 8 weeks? Yes. What is the matter about in this? 8 and 9.
Receive the instructions, Your Lordship. It's a tender matter 8, Your Lordship. We'll file our affidavit, Your Lordship. We have received the instruction.
There's a stay.
No stay, Your Lordship.
Okay. On the prayer of Miss R. Vasa, learned government advocate, listed after 4 weeks for filing of the counter affidavit. Okay. Both 8 and 9.
Wow. Obliged.
This is a transfer case.
Yes.
A engineer officer has been made to replace me. I'm a regular executive engineer, whereas the private respondent is the assistant engineer.
Okay.
So that Himutava case will come.
Hivutama is still the law.
Is still the law.
Okay, then we'll have to interfere.
Now, similarly, today, you know, that Suraj Guru, the Mulpe Tatu has become the law now.
Where is the where is the impugn order?
Impin order, you know, the 23, you know, impin order. 22 and 23.
22 and 22. Yes. You are allowed to.
Yes, I am in serial number 3.
How long you have been there in Alo?
Well, 10 years, there is no quarrel on travel. I'm not quarreling on anyone.
All right.
Kindly see this serial number 2,
2.
Olam Pang. E Tawang UD division as EE Alo Viceroy Halliway. But his recent transfer order, my lord will kindly come to page 25.
20?
25.
25. Yes.
This is okay, block, which date it is. Okay. Just I am trying to see the date. Well, just issued after 3 months. The first order was impugn order was issued on 15/6, and then this before this. Olam is in charge, my lord.
In charge.
In the interest of public service, the governor of Arunachal Pradesh is pleased to order the following assistant engineers to hold the post of executive engineer in their own pay scale as indicated above.
Housing Department.
Housing.
You are representing.
Yes, number 2.
Is a regular EE or?
Friendly mark is not regular.
Okay. Where have you stated in your affidavit? Sorry, in the.
Milord, I have stated here. Para 10 also I have written as there's 11. Page 11, para 11. That the humble petitioner submits the impugn transfer and
Okay,
posting
all right. He is an assistant engineer.
assistant. That Hibutama will cover
All right.
para 62 and 63.
Apu is representing both or respondent 1 is represented by Nama? Okay. What is the reference of Hibutama?
I said they are not similarly situated.
No. Reference, citation?
Righteousness is 2024 GLT. Para 62. I have the copy.
2020.
4 GLT.
4 GLT.
Yeah, para 62 and 63 about that.
This petition is directed at Mr. Chilipar on account petition RS number 1 and Tapo for 2. This petition is directed against. Page 25, huh?
Yes.
No,
23.
23. Oh, yes,
22 is the
22. This against order dated
15/6/2023.
Next page is locking point.
or next page. 15/6.
Yes.
2023. Issued by the Commissioner, UDNH, ULB and TP, Government of Andhra Pradesh. However, the petitioner, who is an executive engineer, ALO, UD division, has been transferred and posted. Has
To a non-sanctioned person.
has been posted
In the office.
in the office of the chief engineer, UD Itanagar.
Correct.
And in his place, respondent number 3, shown to be an executive engineer, Tawang UD division, has been brought in. Also, the contents of the petition is that though the respondent number 3 has been shown to be an executive engineer in the impugned order dated 15/6/2023, but the respondent number 3, in fact, but the substantive post of the respondent number 3 is assistant engineer, and the respondent number 3 is holding the he is functioning as an in charge
In charge.
executive engineer of Tawang UD division. Also, the petitioner therefore contends that the petitioner, who is a regular executive engineer, cannot be replaced by the respondent number 3, who is not an executive engineer, but an assistant engineer discharging the function of the executive engineer on an in-charge basis. And therefore, the petitioner and the respondent number 3 are not similarly situated person. In support of his contention that the transfer and posting in support of his contention that the petitioner cannot be replaced by an assistant engineer or in charge executive engineer. The counsel for the petitioner has placed reliance on the decision rendered by this court in the case of Hiru Tama versus State of AP 2020 4GLT 503. Mr. Tapo, standing counsel for the UD and Housing Department, has fairly submitted that the contention raised by the petitioner insofar as the status of the respondent number 3 is concerned is correct. Also, the respondent number 3 is an assistant engineer discharging the function of an executive engineer of the Tawang UD division on an in-charge basis. Also, issue notice returnable in 4 weeks. As additional legal general and Mr. Tapo, an standing counsel for the UD and so, have accepted notice on behalf of respondents 1 and 2. No formal notice need be issued. To respondent 1 and 2. Extra copies of the writ petitions shall however be furnished to them during the course of the day. The state for service of notice of response by both ways within a week. Also, considering the nature of contentions raised as above, that the petitioner who is an executive engineer has been sought to be replaced by an assistant engineer or the assistant engineer, the impugn order dated so and so issued by so and so shall remain as such.
My lord, can I just ask for a shorter that because your lordship has only passed the interim order and there is a private respondent, my lord. So instead of 4 weeks, can it be 2 weeks or something like that? My lord?
No, why 2 weeks? By that time you will be able to file affidavit.
No, at least my lord, the private respondent might have said something, my lord, for spot.
Let it be 2 weeks.
My lord,
If anybody would like to file an application for modification, etc., it will be listed as and when it is filed.
very well.
Well, government has the option still. If they find a regular executive engineer, they can replace me.
We'll leave it to both of them.
Yes, after 4 weeks.
For it.
Grateful.
May I please, your lord.
Yes.
It is the facts of the case was heard in last week.
Hmm.
So may I take your lordship to straightway to the
Impugn order.
impugn order.
Page.
Page 58. Annex 10, page 58.
Yes.
You. Yes.
Yes. Now, may I read the order?
No, you wanted modification of particularly which part? At page 59, I think.
Yes, 59, lordship.
You belong to?
Lordship, this item number 1, Tariko Tari should be distributed among clan members of Lora Uru equally.
This you want to be
Yes.
interfered with. You are Tarikotari.
No, Tariko Tari is a place.
Oh, Tarikotari is place.
And
Okay.
Lora Uru is in a broader term.
Okay.
It should be Lora Taling Uru.
Okay. So notice will have to go.
Yes. Okay. And Lordship, I have interim prayer that this order may not be implemented.
Any chance of implementation?
Lordship, I have made a prayer.
Okay.
We,
Mr. Huh?
This is 2016 order.
But this is without jurisdiction.
Not set. That
Ah.
is-
So,
Across the secretary, but
no, this is not even secretary. This is a private land. There is a dispute going on between the this amongst themselves.
not set.
So they rush to the deputy commissioner pass some order. That is the issue. This writ petition directed against 3rd March 2016 issued by the deputy commissioner 0 by number so and set page 58 to the extent in the said order it has been observed that inverted comma the Tarigo Tari should be distributed among the clan members of Nora Uru equivalent. Full stop. Inverted comma clause. That you will find at page 59, clause 1. You are also a member of Laura Oro.
Broadly, it's Lora.
Oh,
But again, under Lora, there are sub-clans again.
okay.
Three sub-clans are here.
The petitioner who, petitioner is only one.
Yes,
This is what? Petitioner is a clan or what?
each person.
Or petitioners.
Yes, petitioner.
The-
are here.
Petitioners, comma 2 in number, though claims to belong, though claims to be a member of Laura Uru, is agreed by the finding of the deputy commissioner recorded as above on the ground that the deputy commissioner does not have the jurisdiction to decide the civil dispute between the parties. Of course, you should notice a return over in 6 weeks. As Mr. Ete, granted additional senior government advocate has extended notice on behalf of one, no formal notice litigation. The steps by both ways within a week on 2. First, considering the nature of contention raised by the petition, that the deputy commissioner has no jurisdiction to decide civil dispute of the parties in the interim, it is provided that the impugned order dated 3rd March 2016 issued by the DC0 by number so and so. To the extent it has recorded the finding that finding to the effect that the Tariko Tari should be distributed among the clan members of Laura or equally shall not be given effect to. Listed after, one is extra copy.
Oh, nice.
Well,
Yes.
but just seeking a direction upon the respondent authorities to conduct the DPC
Hmm.
and regularize or absorb me in the IMC Milord, which is since I have been transferred. Well, it is like this. Earlier, the petitioner was in the PWD 2008. Then in 2013, she was transferred to the UD department with post and manpower. Then thereafter, what happened, Milord, the UD department, there are 3 directors, Milord. So then finally that director, urban local body and town planning was separated. So now under section 36 and 41 of 2007 Municipality Act, that we need not to go below. Under that, what happened? The officers of the urban local body, being the cadre controlling department, they sent on this officer to the IMC Pasigat and IMC Itanagar. So there, the condition was that subject to the recruitment of the cadre by the municipal bodies. So then in the meantime, on 6 January 2014, she joined the IMC Pasigat by the order of the Secretary UD and Urban Development. So now, thereafter, no DPC was conducted. Series of representation has been filed. Till today, finds no favor from the government. Now, in the meantime, the private respondent joined under me as a junior engineer. And then his case was regularized. And then further, the 5 posts of assistant engineer was created under the urban local bodies. Against one of that post, the DPC was conducted and the private respondent was regularized. Now, in the process, my lord, what is happening is the private respondent number has filed a representation before the Minister Urban Development and ULB and Town Planning, saying that he should be given promotion. So now, my lord, since I am in the IMC for the last 10 years now, down the line,
In which post?
assistant engineer.
Okay.
Assistant engineer. And the Department of Urban Local Body is not conducting DPC, my lord. So once the DPC is conducted, now my lord will understand, my lord knows that even on the deputation also, my lord, deputation first 3 years, in the worst case, another 2 years, 5 years. And then, my lord, there is one notification by the government of India that deputation can be extended up to another 2 years, that is 7 years. Now that is the new thing they have come up. Now, in this case, absolutely no DPC is being conducted for the last 10 years. There is a protracted representations before the authorities, finding no favor. Now, they find special with the private respondent who joined as a junior engineer, work under me, my lord. And then again, 5 posts was created against the department conducts the DPC and regularizes him. And our case is not being considered. So, my lord,
DPC has to be conducted on which provision?
that is under the recruitment rule framed by the urban local bodies.
Page number?
Page number is that. Second DPC wala last page take. No, okay. No, there's recruitment rules. No, recruitment rules. No, what's it? That's one. Assistant engineer, recruitment rules.
Page number?
Yeah, executive engineer. No. It is not there, assistant engineer rule is not there, recruitment rule that we have not. Sorry, that there is a rule, but because we have annexed the executive engineer. Containing that.
You want to be an executive engineer?
I am the senior most in the IMC for the last 10 years.
But in the writ petition, you are asking for assistant engineer.
Yeah, for regularization. And in the even, this private respondent has submitted a representation to the, that is, my lord will find at page 16.
No, see. You want to be, you want the DPC to be held
DPCB to have
for assistant engineer.
assistant engineer regularize me or either absorb me.
So we have to look into the provision, which you have not annexed.
No, but the 1 second, the aspect is, if we peruse section 36 and 41,
Of
the Municipality Act 2007.
Okay, you are relying on that act.
That
Okay, then we'll forget about the rules.
No, there is a rule.
All right.
There is a rule, definitely without rule, there cannot be any DPC. The department has already formed. I will bring it in the form of additional affidavit.
No. You annex it in the, See, we are yet to issue a notice. You are seeking for an amendment of the writ petition.
No, I'm not seeking, I'm not seeking for the amendment. Otherwise, I have the option always under order 23 rule 1 of the CPC by filing one IA to withdraw this application. That is the procedure. But today, since I am only seeking issuance of the notice, and my lord will only make an observation pending disposal of this writ petition.
Had Mr. Titita, Direct Counsel for the petitioner, who submits that this writ petition has been filed by the petitioner for a direction to conduct, for a direction to the respondents to conduct departmental, to convene a meeting of the departmental promotion committee for the purpose of promotion or regularization.
Regularization.
Is there a provision for regularization in the AE? Are you sure?
It is absorption, my lord, because my lord,
See, regularization, absorption, all different.
I bow down. my lord.
So
I bow down, my lord, for that.
let me not make any observation at this stage.
Issue notice, my lord.
No, how can we issue notice when the rule itself is not there? At least you take the trouble of annexing the rule which you are the rule of the post where you want to be absorbed.
With a gracious liberty, my lord. With a gracious liberty, I am withdrawing it to file fresh.
No, if you want the writ petition to be kept pending, we'll keep it pending. But in the form and content, this court can't issue notice.
That I have to respectfully bow down, my lord. Once
Okay.
there is a finding by the court, as a duty bound court officer, if I don't follow it, it will not look good also. After all, it's a rule of law we are following, my lord. We have to follow the rule of law.
So finally, what is your submission?
With a gracious, respectful submission for granting liberty to file afresh. Withdrawing it. Only to annex that AE's recruitment rule.
You file an application IA for withdrawal. Okay.
Well, at least kindly.
CPC, you are referring to some provision of CPC.
No, well, CPC, that's what defined in section 141 of the CPC is, it will be applicable only in spirit, my lord.
Graciously file one IA.
No. That is in spirit, my lord. So,
Mr. T.T. Tarwar, counsel for the petitioner, has submitted that though this writ petition was, okay, forget it. Mr. Tara, 6 with liberty, okay.
great, my lord.
Okay.
Minor, there is an order of this court dated 22/3/2022, minor, to list the matter along with WPC 1286 of 2016, minor. 1286 of 2016, minor. This was, my lord, was filed by other minor similarly situated minor or like that of a petitioner minor before the principal say challenging the minor recruitment rule, minor.
That 1286.
Yes, madam.
Okay.
Those will find the order dated 22/3/2022.
Where is that?
No, madam, the order in the order sheet, madam, in the petition. 22/3/2020.
You mean to say that this writ petition has come on transfer?
No, madam, the other pending petition, madam.
Oh, another writ petition.
Principal.
That is not listed today.
No, madam.
What is this matter about?
This matter here, I am challenging the minor, the impure seniority list and the minor. On the basis of that seniority list, minor, further officiating promotion has been given to the private respondents, minor, to the post of minor assistant superintendent, minor.
Okay.
And the recruitment, minor, the earlier the rules provide, minor, the promotion can be made only from the minor booking clerks, minor. Now, minor, they have minor amended the minor the rules whereby minor even minor the conductors can also be promoted, minor, to the post of assistant minor superintendent, minor. My basic challenge in this recruitment, minor, challenging the minor seniority list, minor, that was the respondents, minor, who has obtained their degree in the year 2009 and 2012 were placed above me, minor. And whereas I am a graduate in minor of minor 2002, minor. Minor law is minor very well settled, minor.
Just a moment. Why did you point out this WPC 1286?
Because minor in that WPC minor rules were challenged, minor. Some by the petitioner similarly situated like me, minor. They have challenged the rules, minor, and whereby minor in that proceeding, minor, the
What is that rule? Rule
rules
for promotion?
promotion, minor.
Okay. That is pending adjudication.
Yes, minor.
All right.
And minor, there is a stay, minor, of the minor further promotion of the respondents, minor.
So here you are challenging the seniority position.
Seniority and the
Promotion given to the private
private
respondent.
respondents, minor.
So there, what is forbidden? for the promotion.
for further promotion, my lord.
This, the private respondent has been the matter needs to be listed together or what? No, it can be independently adjudicated.
My lord, may I pray that, my lord, it can be independently executed also, my lord.
Hmm. Yes, it can be.
You are also very respondent.
Ah, it is filed by some other person. Okay.
Same thing. Only the particular.
But there the rule is under challenge.
Rule is understood.
Then it will be, that will be before the division bench.
Division, before the division. bench.
If you say that it can be independently adjudicated upon, then we may.
If the rule is informed, in their favor, then it will go. It has to be according to that.
Hmm.
If it is not, then it is. In fact, that is the main thing.
Well,
I don't know, I don't know.
Then may I pray that, my lord, this matter be, my lord, listed along with that.
No, that will be before division bench again.
Yes, my lord. If it is, my lord, here, my lord, we will make a mention, my lord. But if it is listed, my lord,
Let us see the rule which is under challenge.
rules, my lord, also will find. At page 51, my lord. And relevant person is at page 53, my lord.
Page 51.
And relevant person is at page 53, my lord. Column 11, my lord.
Just a
50.
moment, just a moment. 50,
53, my lord.
53. Yes,
And column 11, my lord. 50% by direct recruitment on the basis of combined competitive examination by APPSC and 50% by promotion, failing which by transfer on deputation. And column 12, my lord. Promotion from amongst the serving UDC, line checkers, booking clerks, conductors who have rendered 6 years of the regular service in the grade possessing education qualification for direct recruitment. And this has been, I have been instructed by, this has been my lord challenge before the division bench, my lord. Whereby, my lord, the feeder cadres, in the feeder cadres, my lord, the UDCs were also included, line checkers included, conductors were also included, my lord.
yes.
Because, my lord, UDC has their own promotional avenues, my lord.
So you are now what, booking clerk?
Booking clerk, my lord.
He was also booking clerk.
Some of them booking clerk and some of them conductor, my lord.
No, how many respondents are here?
3 respondents, my lord.
3.
2 are booking clerks and 1 is conductor, my lord.
One is conductor. You are challenging the seniority position assigned to 2 of the respondents.
Private
in-
respondents,
in
my lord.
booking clerk.
Yes, my lord.
Okay, then thereafter, you challenge the promotion order.
Yes, my lord. The other
Dip-
booking clerks, my lord.
DPC was held.
No, my lord, that was, my lord, barred by the division bench, my lord.
Oh, then how he was promoted as?
My lord, now, my lord, on officiating basis, my lord.
Okay, on officiating basis without DPC. Then essentially, we have to decide the seniority position. Okay. Then for deciding seniority position, this rule is not, there's no necessity to refer to this rule. Is not it?
My lord, yes, my
Uh-huh.
lord. Yes, my lord.
Yes, it is for the purpose of promotion only, it can be referred to. Yes, seniority list, where is that?
Seniority is
Booking
that,
clerk.
my lord. Then, my lord, seniority, my lord, in my lord, paragraph, my lord,
Do you have a list, have you annexed list of
seniority list, my lord.
senior list of booking clerks?
Yes, my lord. It's a combined seniority list, my lord. Lords will find at page 64, my lord.
64. Yes,
My lord, respondent number 4 is serial number 2, my lord. And he is a booking clerk, my lord. Remark, my lord. Graduation 2009, my lord. After entry in the service, my lord.
See, this combined, maintaining combined seniority list of this
Booking clerks, my lord.
booking clerks, line checker, UDC and conductor is permissible.
Well, because of this recruitment rule, my lord, this is permissible, my lord. Feeder cadres are given, my lord, in the rules, my lord.
All of these have no further promotional avenue except the assistant station master.
Yes, my lord.
Okay. All
In
right.
some UTCs, they have their own further promotional scopes, my lord. Avenues, my lord.
Then there has to be a separate seniority list of the UDC also.
Yes, my lord. But they have combined together, my lord.
Okay. Yes, petitioner is at
Petitioner E8, my lord. Serial number 18, my lord. Lordship will kindly see, my lord.
18.
Yes, my date of joining 1/12/2000, my lord. BA. Booking clerk, my lord. Graduate in 2002, my lord.
Hmm.
And rest, my lord, minus in private respondent number 4, he has serial number 2. He has obtained a degree in the year 2009, my lord.
Degree is relevant.
My lord.
Degree is relevant.
Relevant, my lord. Now, my lord, under the rules, my lord, there has to be, my lord, graduate, my lord.
Booking clerk rules.
My lord, yes, my lord, this rules, my lord.
All right.
And my lord, serial number 6 is the respondent number 5, my lord. He has also, my lord, obtained his degree in 2009, my lord. Likewise, my lord,
Serial number 6 is respondent number.
5, my lord.
Okay.
That's why, my lord, they cannot be, my lord, merged over us, my lord. Because, my lord, the apex code, my lord, I have my category will mention is mentioned at page 22 also, my lord.
Hmm. Hmm.
And N. Suresh Nanthan and another versus Union of India and others 1992, Supply 1, SSC 584, my lord.
Just a moment. TN Akka. R4. There are two private respondents only.
My lord, yeah.
I will be taking for him.
Yes.
Sometime will be given.
Is it? Okay. Then when?
Any day except today.
Okay. When?
My lord, if it's in the next week,
Okay. then.
no.
Our secure and constitutional and Mr. R. Vasa for government, State, and Mr. A. Apong, senior counsel for 4 and 5, I think. No, 3 and 4. Oh, 4 and 5. 4 and 5. On the prayer of Mr. Apong, senior counsel for R4 and 5. To list it after 1 week, 2 week, 1 week. Okay, after a week. Yes.
Here was again was my senior mentioned. It's for adjournment lawsuits.
You are for the petitioner,
Yes, lawsuit.
JZM.
Yes.
You are for whom, Mr. Modi?
I have for private respondent number 6.
Who is respondent number 6?
CPO, my lord.
APR, since my name,
APO.
I have been made by name, so I am APR. Otherwise, my the action of what was done was under the capacity of the government. It should not have been in the name. But one thing, my lord, if the today's praying for the adjournment is success, my lord, this will be 24 time of the adjournment in this case.
Okay.
In the name of my lord, the
JZM.
two senior, particularly in the many occasion on behalf of the Tea Garden And in many occasions in the, on behalf of the.
All right. Then between you and Wangmo, who will open the case? Who will argue the case?
Arguments, I will go with the argument of the government.
Huh?
Because I'm the government of the state.
Okay, yes, let us hear you.
And I will.
Here, last occasion, adjournment is taken, Lordship, but Lordship, this court allow, after the filing of the epidemic by the.
But this court is not inclined to allow.
We were supposed to-
You may, see, we are not on Mr. Modi's,
File the rejoinder, Lordship.
see, Mr.
Yeah.
We are not on Mr. Modi's submission. He says that you have taken as many as 10 adjournments, 10 or 20,
So for.
24.
23.
23, not on that. Even if you had taken only one adjournment, having regard to the fact that this repetition pertains to 2016, court is not inclined to assume this matter. Yes,
Yeah, my lord, petitioner is claiming, my lord, that
don't be under the impression that it is because of the Modi's submission.
No, Lordship. I have-
That 24
This court, here is a dispute, Lordship, a dispute between the government disputed Lordships as claimed by the petitioner Lordships, Bills Lordships.
Government is disputed.
Yes, Lordship.
You
So-
file a suit then.
That's Lordship. So the Lordship, at least Lordship, I have some I prove Lordships, you can get interpreted by the council. This is the reasons for Lordship, you appear Lordships, they didn't Lordship. If infected Lordship. The I prove.
Have,
Yes, Lordship.
see, Mr. Baum, have you filed affidavit in reply?
no,
I think that is not filed, Lordship.
That is not filed till, that is not filed. Do you have any idea how many times you have taken adjournment for filing of a rejoinder?
Lordship, Lordship, I think one time.
You only think, you think that it is only one time.
Yes, Lordship, yes, because Lordship.
This case record has come to this court for the first time.
Lordship, this court, Lordship, directed to the petitioners to file the rejoinder, Lordship. I think the.
Court never directs to file a rejoinder. Court also never directs to file a counter affidavit.
when matter was.
Mr. See, let us, you be very clear about it. Court never directs to file a rejoinder or a counter affidavit. Court just gives an opportunity if anybody would like to file a rejoinder or a counter. Why should the court direct you to file a counter affidavit?
The final arguments, well, I am also present on the occasions when.
So therefore you take your seat unless you want more disclosure from the record, how many adjournments you have taken? Let us hear Ms. Wangmo, if case can be disposed of, we'll dispose of. If not, we'll adjourn it and give you time. Is not it? Yes,
yeah, my petitioner's claim, my lord, that some extra amount was deducted, my lord, from the original bill, my lord. We have filed our affidavit, my lord, and kindly see my affidavit, our affidavit. My lord.
Hmm?
Our affidavit, my lord.
No, don't come to your affidavit first. Since the counsel for the petitioner has not opened the case, you tell the court, what is the prayer of the petitioner? And what is the basis of the prayer made by the petitioner?
Petitioner, my lord, they have claimed, my lord, that some extra amount were deducted from the original bill, my lord.
Original bill.
Yes, my lord.
What was the bill about?
Bill amount was, my lord,
What was the bill about?
it was regarding the construction of staff quarter, my lord.
Stop quarter. Where is the NIT?
My lord, there were 11 petitioners, there are 11 petitioners, my lord.
7 petition.
11, my lord.
Where is the NIT issued, work order issued pursuant thereto? And the bill settled?
Sanction order, my lord. There's sanction order, my lord.
See,
Sanction order.
Ms. Wangmo, court is unaware of anything about the case.
Yes, my lord.
You have to present a case.
My lord, there were total amount was, my lord, 101 crore 49 lakhs, my lord. That amount was sanctioned, my lord, for implementation of various scheme under SDPP, my lord.
Hmm.
And from that, my lord, 27 persons were given, my lord, to work, my lord. different works, my lord, under the scheme. And here, my lord, in this petition, 11 petitions are there, my lord. They are claiming that their amounts were deducted, my lord, total amounts were deducted.
Hmm.
That was the case, my lord. Only this one.
Hmm?
Only this one.
Okay.
Yeah. So, my lord, here, my lord, we have filed our affidavit, my lord, saying that, my lord, the
Yes,
affidavit was, yes, madam. The amount was given, madam. Total amount was given, madam, to the petitioner and all the petitioners, madam, 11 petitioners, madam, and they have accepted the bills, madam. And it's in page number 13, madam. First petitioner number 1 name, madam.
Yes, 13.
Yes, madam. Page number
Yes.
13 in our affidavit, madam.
Yes.
24, madam.
Hmm.
Serial number 24, Lokam Sangma.
Hmm.
He is petitioner number 1, madam.
Yes.
And here, madam, kindly see, madam. Renovation of SPT 2 unit staff quarter at Tamil, madam.
Hmm.
Total amount was 5 lakhs, my lord, and he was paid 4,73,335, my lord. Because, my lord, L says 4,878 was deducted, my lord. 4% VAT was deducted, my lord, and royalty was deducted. Only this much, my lord. These three. Page 13, my lord.
Hmm.
Then total amount, my lord, 26,665 was deducted from the petitioner's bill, my lord. This was by the department, madam, because this comes under LSS bills, VAT bill and royalty bill.
Hmm.
And royalty is for the building, madam, and madam, and this is 27, madam. Serial number 27, madam. Here, my royalty was not deducted, madam, because this was for the construction of general ground, madam. It's only this much, madam. They are claiming, madam, this shouldn't be deducted, madam.
Okay. Then,
According to us, my lord, this was deducted from all the petitioners, all the 27 contractors, my lord,
hmm.
and only 11 are here, my lord, petitioner, my lord, and the different. And here's one copy, my lord. May I produce, my lord?
No. We'll not look at any document which is not here. What is
This was
that?
asked for, man.
Asked for?
Yes,
In the last order?
yes. 23 to 23.
23, 2.
223. Original records were called for, my lord, but due to this RD department, my lord, they are not a party, my lord. That's why we couldn't what the original records, my lord. But Xerox is here.
Who is respondent number 6? APO.
APO.
That record has come from APO.
No, my lord, actually APO now, my lord, APO comes under DR, RD department, my lord. And
Ah.
RD, they have their standing council, my lord.
No, that record has come from where?
From my lord,
APO,
deputy commissioner, my lord.
Deputy Commissioner.
Yes, my lord. Because my lord,
Deputy
Yes.
Commissioner has filed an affidavit.
yes, earlier, my lord. Earlier DCS file, my lord, but. after-
Earlier, no,
Yes,
no.
it's my lord, 2016 matter, my lord. So my lord, in 2021, there were,
Deputy Commissioner is which respondent?
there were 3, my lord.
3.
Yes, my lord.
Okay.
But my lord, after 2020, my lord, this RD department, my lord, they take over the RD department. It's their standing council, my lord.
Now, what is that document which you are? Which
Then
you
my
are,
lord petitioner has already accepted the bill, my lord. They have taken the money, my lord. This only. And
according to you, there was no deduction.
no, there is deduction, but that was royalty and yes, my lord.
Yes, let us see the document.
This is already annexed in the petition, my lord.
Annexed in the
affidavit.
petition.
Yes, in our affidavit.
Page number.
In page number 13, my lord. Petition number 1 is in section number 24. 24 and 26. my
Just
lord.
a moment. Page number 10,
13.
13.
Yes, ma'am.
How many petitioners are here?
11.
11.
Total, my lord, there were 27 contractor, my lord.
Page number 13.
13, 1, 3.
1, 3, serial number
24 and 26, my lord, same petition, my lord.
24. Okay.
He was given two, my lord.
This person is petitioner number
1.
1.
Yes, my lord. And my lord, his sanction order is in page number 21 of the petition, my lord, of read petition, my lord.
Just a moment. Page number
21, my lord, of the petition, my lord, read petition.
uh, page number
21.
21 of the writ petition.
Yes, my lord.
Five lakhs. Just what is they had shown in which paragraph? Paragraph 4 of the writ petition. They have shown the deduction made in paragraph 4.
Yes. Petition amount is 5.
Just yes. Total amount deducted. He was awarded work of two works,
Yes, my lord.
5 lakhs each.
5 lakhs, 10 lakhs, my lord.
Okay, then according to him,
Yes, my lord.
only he was paid 3,11,335 each,
Yes, my lord.
and you had deducted
1,88,000.
1,88,000,
Yes, ma'am. But
which you have denied
yes, ma'am, in our affidavit, ma'am.
at page 13.
13, yes, ma'am.
You have said you have paid 4,73,335.
They have signed it also, my lord.
They have signed it also. Only the deduction was 4% VAT. What is this? Okay. L cess means L
Else, yes, ma'am.
labor
Yes,
cess,
yes,
labor. Royalty, okay,
royalty.
royalty.
And total deduction was
Okay.
26,665, my lord.
All right. These deductions are justified,
According to us, yes, my lord, because department.
VAT,
deducts-
etc.
Yes, my lord.
All right. This is in case of petitioner one,
Yes, my petitioner one.
P1. Serial number
24 and 25, my lord.
24 and 25. Okay, P2,
Is in serial number 9, my lord, page number 11.
P2 is serial number 9.
Yes, page 11.
Yes, Mr. It appears your case is going. Huh? You said one lakh in case of petition,
28,000.
the petition number 1,86,000 was illegally deducted from the total bill of 5 lakhs. That was your allegation made in 2016. They have filed an affidavit saying that no, it was not deducted. And you had paid 4,73,335. Only deduction made was
26,665.
that 4% VAT, royalty, etc., coming around about
6,000.
26,000 euro. And this affidavit was filed when
2019, my lord.
9th September 2019.
And
Since 2019, you have not filed a rejoinder denying this. And you are taking time after time to file a reply. We are closing it. Huh? There's nothing.
I have not-
Yes,
Please,
petitioner 2.
Petitioner number 2, my lord. Is in
Yeah,
serial number 9, my lord,
serial number 9.
page 10. No, page 11, my lord.
Serial number 9. Ruba. Ruba.
Serial number 9, man. Page 11.
Yes.
Here also same, my lord.
What is the name of the petition?
Hinium Tame.
Okay. Petition number 2,
Yes, my lord.
serial number 9.
Yes, my lord.
Are you sure? Are you sure? Helium?
Yes, my lord.
Because we have to tally it with from the post title. Mr. Modi, you also cross-check while Ms. Wangmo is pointing out the name and the amount and the serial number. Okay, P2 is at serial number 9, is not it?
Yes, my lord. And
And serial number 9, sorry, petition number 2, Mr. Bam.
Yes.
He has been paid 4,95,000.
yes, my lord.
Only
5,000.
deduction was 5,000.
Else is only deducted, my lord.
I have no idea about this.
Okay, all
So
right.
that if I submit
Then
for item.
in case of petitioner number 2, only
5,000.
one work.
Yes, my lord.
Serial number, yes, P3,
Petitioner number 3, my lord. Page number 12, my lord.
P3, serial number. You just say the serial number.
21, my lord.
21.
Yes.
21. Yes. All right. Then P4, with little bit of this exercise, this writ petition could have been closed in 2019.
If lawsuit payment is made like this lawsuit, this would not be case like that.
But you have not denied
20,
it.
my lord.
Huh?
Page 20, my lord.
Just to cross check lawsuit whether my petitioner lawsuit received the such amount lawsuit instructions is sufficient lawsuit. In this
But-
case, suppose if. this
We are not
appear
denying
like
that.
this,
Mr. You, why don't you appreciate?
lawsuit
You have been given opportunity to deny this fact. Since 2019, it appears the petitioners are not interested to contest the case. Yes,
20, my
P4,
lord. P4 20, my lord.
20,
Yes, my lord.
okay. P5,
Here, 8, my lord. Serial number 8, my lord.
P5 is serial number 8.
Yes, my lord.
8.
P6 is in serial number 10, my lord.
P6, 10. P7,
12,
P8,
19, my lord.
19, P9,
23, my lord.
23, P10,
11,
11, serial number 11,
yes, my
and finally P11.
Yes.
Yes.
lord. 15, my lord. 15,
15.
yes, my lord.
Modi, is it correct? Okay, except for this P1, who was awarded 2 works.
Yes, my lord.
All of them have been awarded only one work each.
Yes,
Okay. Yes, for the satisfaction of Mr. Bang, let him show this to him.
No, no, I have second copy lost.
Huh?
I have second copy lost.
You have seen the dates of filing of the counter affidavit?
No, Lordship. Yes, I seen Lordship.
No, no, not that. When that affidavit was filed by the government.
Let's see. It is filing again. 2019.
Date also you specify?
Yes, that is specified.
Which date?
21/8/2019. As for this, second copy. Lordship.
It is not 21.
9/9/2019.
It was 9 September.
I
See,
didn't.
no, no. 21st August, 21/8/2019
Yes, Lord.
was the date when affidavit was signed by the deponent.
Yes, Lord.
Then it was filed on 9 September, which means copy was also served upon you on 9th. T. Kamsi had received it. That was enough opportunity.
Yes, Lord. No, no issue.
Is not it?
Receipt.
You are satisfied? Then we'll dispose it of.
Please, Lordship, just only Lordship, if this sign is the petitioners or not, Lordship, I cross verify. Lordship. Their affidavit, Lordship. Page number 10, 11, 12, 14, 13.
Modi, is that correct? Name of the petitioner and the serial number pointed out?
The same thing I have already filed in the month of July 2009.
I have Mr. Jivan, Learned Counsel, who prays for an adjournment on behalf of Mr. J. Jini, Learned Counsel, for the petitioner. Mr. M.S. K. Wangmo, T. Wangmo, Learned Government Advocate, for
1 to 5.
respondent 1 to 5. And Mr. C. Modi, Council for respondent number 6. Though an adjournment has been sought for by Mr. G. Brown, Council for the petitioner on behalf of Mr. J. Jini, Council for the petitioner, having regard to the fact that the writ petition pertains to the year 2016 and the nature of issues raised in this writ petition. The writ petition is taken up for final disposal. The petitioners have filed this writ petition claiming a payment of rupees 30,10,999,999, stating that the opposite amount is the amount illegally deducted by the respondent authorities, including the private respondent number 6, from the total sanctioned amount of the various works executed by the petitioners. Full stop. The detail of deductions made in respect of each of the petitioners amounting to rupees 30,10,999 have been indicated in paragraph 4 of the writ petition, which are as under. The petitioners altogether 11 in number, huh? Then which are as under. Yes. We quote the table. Full stop. The state respondents, the respondents number 3, 4, and 5 have contested the case by filing a counter affidavit, wherein in paragraph 6 thereof, it has been stated that no excess deduction as alleged by the petitioners was made while making the payment of the bill of the petitioners. Full stop. It has also been indicated in the counter affidavit by annexing a letter dated 18th March 2016, written to the block development officer, CD Block Damin, Kurungkume district by the district planning officer, Kurungkume district Kolonel by number so and so at page 9 of the counter affidavit by 2, 3, 4, and 5. Annex 9 question of the wherein it has been indicated the net amount wherein it has been indicated the net amount payable to the petitioners and the net amount paid to the petitioner and petitioners and received thereof out of the total out of the works awarded to each of the petitioners for rupees 5 lakhs each, which are as under. Then you Then you write in the table. Name of the petitioner. Name of the work. Amount. Deduction made. Net pay, net amount. Payable. This is the table. First of all, from the above, it transpires that the deduction alleged to have been made by the petitioners in paragraph 4 of the writ petition have been denied by the respondents 3, 4, and 5 as indicated herein above, wherein the deduction made appears to be the deduction made from each of the petitioners appears to be a negligible one and permissible deductions such as L says, L stock says, 4% VAT, and royalty. Full stop. Full stop. All the petitioners have been, all the petitioners appears to have received an amount exceeding 4,70,000 after the apostate deduction was made. And accordingly, the respondent authorities did not make any illegal deductions as alleged in paragraph 4 of the writ petition. Full stop. The counter affidavit by the respondents 3, 4, and 5 was filed on 9th September 2019. Also, since then, though the petitioners though the learned counsel for the petitioners have been taking adjournment for filing of the rejoinder affidavit, no rejoinder has been filed by the petitioners denying the amount stated to be paid to each of the petitioners in the counter affidavit filed by the respondents 3, 4, and 5 as indicated here in above. In that view of the matter, in that view of the matter, there's no reason to disbelieve the stand of the respondents 3, 4, and 5 that no illegal deductions was made from the petitioners as well as petitioners what sanction bill or etc. As well as, but whatever the deduction was made was a legitimate and permissible deduction under the law. Full stop. In that view of the matter, no writ in the nature of mandamus as sought for by the petitioner can be issued directing the respondent authorities to pay to the petitioner the deducted amount from the bill of the petitioners. First of, accordingly, this writ petition shall stand disposed of with a liberty granted to the petitioner if they are at all aggrieved by the deductions made as per the letter dated 18 March 2016, written to the block development officer, CD Block Damin Kurungkume District by the district planning officer, Kurungkume District by number so and so, as indicated herein above. The petitioners may take a recourse to may take recourse to appropriate remedy before the appropriate authority or the court of competent jurisdiction as may be permissible under the law. The petition disposal with the above. In terms of it. Yes,
Well, that Mithun case.
influxus. Oh, this is Mithun case. Okay.
My lord, because the Mithun is dead now. Mithun is dead now and both the parties are litigating.
So can we close it?
It will be closed, both the parties to approach appropriate forum if any disputes still exist.
Yes.
I think that will be better.
Yes, but I had a loss to understand how for the determination because the subject matter of this is no longer there.
Oh, there was some finding against you also in the order? No, nothing. Okay.
Well, without going.
Then can it be closed because the subject matter is dead? If both of you say so, we'll close it.
Yes, that's right. But if
Then anything is to be said as said.
What purpose is this? Your notice said as a company finding and may not give them a liberty to approach the appropriate forum that if it is exercise nothing remains determined. Living thing was the subject matter of dispute.
But can we simply close it on the ground that Mithun is dead? Is not it?
yeah, it will not adverse to any party.
Mr. P.T. Tara, counsel for the petitioner. Ms. R. Vasa, learned government advocate for the respondent
1, 2, and 3.
1, 2, and 3. And Mr. D. Pangil, learned counsel for the respondent number 4, have submitted that the issue raised in the instant proceeding pertains to a Mithun, which is dead now. First off. In view of the aforesaid fact that the subject matter of the instant proceeding itself does no longer exist, learned counsel for the parties have submitted that this writ petition may be closed. As submitted by the counsel for the petition.
And
this
then,
writ
well,
petition
accordingly,
is
the
closed.
impugn order may be merged along with this petition.
What is that impugn order?
Impugn order, some penalties are there.
Penalty, your can that I agree. The penalty that can be yes.
That can
Okay.
be waived off
Against you.
against me with 20.
Where is
The
that?
penalty.
Where is that?
Page 72.
72.
Very confusing.
This is
No, I think
Oh,
it's 79
79, sorry.
and translated book is 89.
89.
Kevin, this one is under challenge here.
Yes, it's Kevin.
Okay. ATU.
And these were just countersigned by the EAs.
You are Tangir, you are Tajir Palang.
Yes. One is PI, another is HGB. Both of them have developed ego over a debt Mithun and litigating for long.
What is that part where you have been? imposed?
Kindly serial number.
Five.
Yeah, yeah.
Okay. 35 said it. Also the fine imposed against Tajir following the sum of rupees 35 be paid within 1 month. Okay.
May I not be record my concession?
Huh?
May I not be record my concession as far as the file is concerned?
Okay.
Yes.
Then you are just write like this, Hudson, so. This writ petition is directed against the Kewang decision dated 17/11/2016.
21, 29, 21, 12.
21 12.
Yes, page 70.
Page 79.
Sign of 29.
Translation copy is where?
Page 81.
81.
Yes.
Okay. Okay, then, yeah. Here, director again, Kewang decision dated 21/12/2016. Issued by the Extra Assistant Commissioner Kaing by number so and so at page 79. Post of. The subject matter of decision by the Kewang in the decision rendered on 21/12/2016 was in respect of the ownership of one Mithun. Postcode. The Mithun, which was the subject matter of a decision of the Kewang dated 21/12/2016. The council for the parties have submitted that the Mithun, which was the subject matter of a decision of the Kewang in 21/12/2016, is now dead. Full stop. In the decision rendered by the Kewang dated 21/12/2016. No, in the decision, in the Kewang decision rendered on 21/12/2016, it was inter alia by clause 5 thereof.
Two also.
2 also.
2 and 3, they have ordered. 5 is the final.
Okay.
25 and 10,000. No, 5.
5 is the
Yes.
ultimate.
5 is the total amount.
By clause 5 thereof. The petitioner. A fine of rupees 35,000 was imposed against the petitioner. Also. Since the subject matter of this subject matter of instant proceeding, namely the Mithun, is no longer alive, and the council appearing for the parties have submitted that this writ petition may be closed. Mr. Tara, the council for petitioner, has submitted that this writ petition may be closed by also interfering with the fine fine of rupees 35,000 imposed on the petitioner by the Kewang decision dated so and so, to which Mr. Panging Learned Council for representing the respondent number 4 has also agreed to. First. In view of the submission made by the council for the parties, since the subject matter of the proceeding, namely the Mithun itself, is no longer alive, this Read petition shall stand closed. Shall stand closed by also providing that by also interfering with,
Say providing that the petitioner will not be required to pay the 35.
okay, by providing
Huh.
that the petitioner shall now not be required to pay the pay the fine, pay the fine imposed on him. Pay the fine of rupees 35,000 imposed on him by the Kevang decision dated 21/12/2016 as agreed to by Mr. Panging and the council for the respondent. The petition stands closed in terms of.
Much less.
Your Lordship, the arguing counsel, Ms. M. Dangan is on legs in the other court, so the matter will be passed over for some time.
Okay, what is the matter about?
That is.
It's
BPC,
reverse the promotion.
Reversal of dealer.
okay. What to do? Next week,
After some time,
Hmm?
Your Lordship.
after some time,
Yes, Lordship. Pass over, yes.
okay, all right. Or we can fix it next week also.
Today after some time, Your
Okay,
Lordship.
all right,
Okay.
okay. Yes,
Lordship, here we have challenge in Indian origin. But as of now, I am informed that the work is already completed, so.
in Texas,
Yes,
Okay.
it can be closed to.
Mr. T. Gatso, learned counsel for the petitioner on instruction submits that this petition is not pressed. Just in view of the submissions, okay, hard Mr. T. Gatso, there is an interim order
No, it has been vacated.
vacated, okay. G. Tarak for
1, 2, 3, and 4.
RWD, okay. Respondent number?
5.
Okay, T. Garam for 5. Mr. Gatso, learned counsel for the petition on instruction submits that this petition is not pressed. First, in view of that, the petition is dismissed and not pressed. Yes,
I'm appearing on behalf of Mr. S.K. Violi in this case.
ah,
We are yet to file an affidavit in reply, so 3 weeks' time may be given.
how much time?
3 weeks' time
3 weeks time, for what?
to file a rejoinder.
Rejoinder. Okay. On the prayer of Ms. T. Y. Bhutia, learned counsel for the petitioners. Listed of 3 weeks for filing of a rejoinder.
Yes, I'm appearing from the respondent number 5 and 6, madam. I'm
Ah.
paying some time, madam, to file affidavit.
Item number 7.
7, madam.
What is the matter about?
No, the matter is, they are saying that we are unauthorizedly occupying their land.
Yes. How much time we require?
3 weeks, madam.
Mr. Non-appears for the petitioner. Mr. Who is the main respondent? You. Okay. Mr. Parmel, standing counsel.
My lord.
for the
Power
power
department.
department, representing respondents 5, 6, 7,
I am for 5 and 6 men.
5 and 6. Request for and is granted 4 weeks time. To file counter,
My lord.
to file counter. You file counter or not?
No, no, sir.
Okay. That above you, right? Non appears. Count for, no. Pangu, you for 1 and
4 and 7 year olds.
1, 3, 4 and 7. Will you file affidavit?
Yes, Lord. We are not received it for us.
Your affidavit will be required.
Yes.
Okay. Mr. Kamruk for 2, land management. And Perme for 4 and 5.
Five and 6.
5 and 6. Mr. Kamruk, Government Islamic Council Land Department, representing 2, has submitted that respondent number 2 would not be filing a counter affidavit. On the prayer of both Pangu and Sensor, 4 weeks for counter affidavit. Okay.
Yeah, my lord, I need some time, my lord, only 4 days, my lord.
Yes. What is the matter about?
Huh?
What is the matter about?
Matter regarding the termination from service on the basis of the information furnished by the SIC.
SIC. Okay.
Only that is the case. So
From which post?
from JE,
J.
junior engineer post.
Okay. Oh, that relating to APPSC.
Yes, my lord.
Yes,
Okay. Mr. M. Patil, London Senior Counsel, assisted by Miss T.Y. Bhutia and Miss T. Wangmo, London Government Advocate, representing all the respondents who press for and is granted further 6 weeks time to file counter affidavit. Listed after 6 weeks.
no, on 12/6/2023,
Hmm.
only 1 week time was given
Hmm.
to file the affidavit. And they also assured to this court that they will file affidavit within a week.
Hmm.
So we are not getting the any interim. In that case, the case should be trial should be expedited. The hearing of the case should be expedited.
I think there are similar matter also.
They are similar method, but some of them got the interim and one who have been deprived the giving of interim.
See,
My lord, only
Many,
1
many of
week,
the
my lord.
petitioners, they have got the interim.
just a moment. How many writ petitions are pending?
My lord. More than 5 minutes.
More than 5. Mr. Patil appears to be correct. Some of them have got interim order. Some have not. It is very unfair. You are not moving an application for vacation of it. In that case, we will grant all interim order. Yes, this is not fair.
Only 1 week, my lord. Next Thursday, my lord, I'll file my affidavit. It's
And
ready.
see, it is the state council who has to organize. Huh? Last time I had asked you to find out pension matters.
There were only 2, my lord.
So
Regarding HSC, my
you
lord.
had given 8, but later on, only 1 matter was found to be regarding pension matters pending on account of NOC. Others were different matters.
Yes, my lord, and there were 2, my lord. One was disposed of by the, your honor only, my lord.
So you give the list of the case on the next date. All right. All the 5 numbers of case. Issue involved is the same. 1 affidavit will suffice.
Next
Is
Thursday.
not
my
it?
lord. Thursday, my lord.
On the next date, we'll see. But will you take any steps or not? You'll be able to find out all the petitions.
Yes, my lord.
Hmm.
Thursday, my
You
lord.
give it on the next date.
After
During the case, my lord, for non-furnishing of NOC, my lord, I have not been considered for promotion.
Promotion?
Yes.
Okay. What NOC?
My lord, no objection certificate regarding non-encroachment of land.
Okay, you have enclosed.
Not encroached, my lord. I was given the certificate to, my lord, construct structure over my land.
Here, my lord, we have yet to receive instruction, my lord.
You have received instruction. Mr. Which post?
Deputy Forest Ranger.
Mr. B. Pichon, one of the petitioner. And P. Wango for all the respondents who press for and is granted
1 week, sir.
No, my lord. 3 weeks.
further 8 weeks time
My lord,
to file. This is promotion letter.
my
What?
lord, I have been denied promotion since 19, my lord, it's 2 decades now.
2 decades.
Yes, ma'am.
But you have approached this year only. Okay,
I am
6,
going to retire, my lord. Yes,
6
sir.
weeks, 6 weeks. When are you going to retire?
Well, I am now 56 years, my lord.
Oh, you have time. Don't worry.
4 weeks time. my lord.
6 weeks, 6 weeks. You bring it.
Good night.
My lord, here the petitioner had challenged some tender conditions, my lord,
Uh-huh.
where there was a specific condition that the intending bidders should bring NOC from the Gaon Bura Anchal Samiti members to,
Jal Jeevan.
no, my lord, construction of road, my lord.
That's-
So, my lord, on the last date, 29/6, this court had granted some interim order where it was said that I should be given a liberty, I was given a liberty to submit my bid. And the authorities shall not insist on those particular clauses where that NOC is being sought.
Hmm.
Now the state has filed affidavit where they have said that they shall not insist on that. So, my lord, may I pray, my lord, this may be listed on Monday or Tuesday, my lord. I will just have a small instruction, take instruction from the.
All right. 16, 16, 17,
Tuesday,
because Monday is 14,
16.
16.
16.
Okay. On the prayer level council, on the prayer must be spoken on the council for the petition. Listen, 16.
16.
Okay, 16.
All right.
Twelve क्या हो गया? 12. Item 12. हाँ? कब? अरे none appears for the parties listed after a week. This is again after a week.
Well, the containers have complied
Yeah.
and they have released the payment also,
Okay.
may kindly be closed.
Learned counsel for the petitioner submits that the order passed in the writ petition have been complied by the respondents. In view of the contempt petition stands closed. What is this IA?
A was for somebody, just,
Okay, in view of the order passed today in the contempt case number so and so, IA also stands closed.
but.
Number 16.
Yeah, Your Lordship, we are yet to file our affidavit. Our affidavit is ready on behalf of 15, 16, and 17,
What is the matter about
land compensation.
land compensation?
Yes.
Okay. You are representing which respondent?
Your Lordship, 1, 6, 15, 16, and 17.
One?
6, 15, 16, and 17.
Okay. Huh? You have written down. 1, 6,
15, 16, and 17.
17. The,
I'm for 2, 3, 7, and 8.
okay.
2, 3, 7, and 8.
And,
my affidavit, I have not received instruction.
okay. Kamrup for?
4 and 5 also.
Oh, 4 and 5. You'll also file affidavit?
Yes, I filed.
Oh. And none appears for the petition, hard sensor, on the prayer of London State Councils. Listed after 6 weeks for filing of the counter affidavit.
Oh.
My Lordship. Lordship, respondents have not still yet to file affidavit, Lordships.
Lordship, affidavit is almost ready, another a week.
Okay. What is the matter about?
Lordship, provisional land allotments, Lordship, my petitioner provisional land allotments cancel, Lordships.
Okay. You are for 2, 3, 4.
I'm for all.
You will also file affidavit.
No, no, here, my affidavit will not be required.
Both the cases are similar.
Yes, Lordship, similar.
Respondents are also same.
Yes, Lordship.
Okay. And Mr. G. Another counsel for petition. And Mr. D. Kamrup, learned standing counsel for land department, written respondent who submits the counter affidavit by either the respondent number 1 will not file a counter affidavit in the instant case. So Mr. Riram, additional senior government advocate representing 2, 3, 4 submits that the counter affidavit is ready and will be filed within a week. And we have now listed after 3 weeks. Okay.
Number 19.
Five. Who are you? Okay, but who had lost the complaint?
No, no, against me.
Huh?
Against her.
Against me.
Petitioner lost the complaint. What kind of a complaint?
I'm going to the government, but government day.
Just a moment. Where is the impugned order? Where is the petitioner's counsel? Impugned order is where? Oh, there's, okay, there's no impugned order. Allegation is that particular quarter has been allotted to the petitioner.
Yes.
And she is undertaking construction within the premises of, yes, where are you constructing? Okay, how much time? Weeks. None appears for the petitioner. Hard. P. Tapo, non-standing counsel for the housing department. Secondary respond R2. 2. One more for 3, 4, 3 and 4. And M. Levo for 5. At the top means after petition, non-appears for respondent number 1. On the prayer of learned counsel. Learned estate count. Okay, the Gamluk is there.
Yes,
I think you will not file affidavit here.
no, sir, here in fact, the secretary land management ought not to
Not-
have been made party also.
Not a necessary.
Not necessary.
Gamluk, who submits, same, not, will not file affidavit. Making of a party. Or the lawyers will have to be a little more organized in making of the parties. Unnecessarily bringing here, see in this case, we have noticed in many cases also, chief secretary has been unnecessarily made a party.
Yes,
So like here, you ought to not to have been made a party.
exactly.
Here the in your place, secretary housing may have been
Yes.
made a party.
Housing and UD, Indian house.
On the prayer of learned counsel for the respondent. Listed after 3 weeks, huh? For filing of a counter affidavit. The interim order passed earlier. Continue till the next date of this. Yes.
This review lawsuit. This Honolulu Court is directed the SSB lawsuit, Staff Selection Board, to recommend the petitioner along with the other lawsuits for selected candidates who were in the waiting list lawsuit. After this judgment has been passed, since in connection to this selection process lawsuit, criminal case is already pending lawsuit. And we have taken status from the authority lawsuit. In respect of one Sri Delhi Ronya, who was at serial number 3 lawsuit. His father is found to be involved in lawsuit, case lawsuit. So he is the beneficiaries of that. So in that due lawsuit, my limited prayer before this lawsuit. Because of this change of circumstances lawsuit, let the authority, that's the lawsuit commission, be decide whether his bid to be lawsuit recommended or not lawsuit. To that extent, if lawsuit, the earlier order can be modified lawsuit. And then a part lawsuit, another one is lawsuit Nirvay Singh lawsuit. There was no quota for lawsuit. There's no quota for lawsuit. Unreserved lawsuit. So on this, so far this Nirvay Singh case lawsuit. Lawsuit was last time also agreed lawsuit. To that extent, modification can be done lawsuit. And so for Delhi Ronja is lawsuit. As I placed last time also lawsuit, I placed one judgment lawsuit.
Let us hear them. We have not issued notice yet, isn't it?
Not yet issued lawsuit.
Actually, notice should have been issued.
Because
We'll take a call on your contention.
Yeah.
But that has to,
but that will not prejudice the lawsuit, Delhi Ronja lawsuit.
why?
Because the authority has to take decision because of change of circumstances only. To that extent, if direction
No.
is issued,
Which authority will take a decision?
the SSB lawsuit.
No, SSB can't take a decision. Decision regarding appointment.
No, decision regarding recommendation lawsuit. Because it was not yet recommended lawsuit. So far, select is concerned lawsuit, not over in merit lawsuit, because cases were already recommended lawsuit. These are the lawsuits, they were in a waiting list, listed in this lawsuit,
Yes.
who were never recommended lawsuit.
Direction was for recommendation of how many?
Lawsuit. All these 5 candidates lawsuit,
5,
who were in lawsuit, waiting list.
3 you have already recommended.
Lawsuit,
Is not it?
yes, correct,
Now, next are these two persons.
2%. Because the
Why?
authority to,
Why you should not recommend them?
because of this change of circumstances lawsuit.
Change of
Prima facie-
circumstance means what?
Prima facie lawsuit, his father is found to involve in the case lawsuit.
No, that will come in the stage of appointment. You are a selection authority.
Selection authority has capacity to decide lawsuit, who is to be selected lawsuit.
But you have selected.
No, so far,
Waiting list is a part of a select list.
once it has been selected lawsuit, review can be done lawsuit.
Okay, we'll issue notice.
Lawsuit, that judgment which I have placed lawsuit.
Which one?
In that case also lawsuit, committee who lawsuit recommended for lawsuit, withdrawal of that particular selection lawsuit.
We'll see. Now,
Because,
just a moment.
yes,
If these 2 persons can be denied, denied recommendation on reasons bona fide, then in their place, you will have to recommend yet another 2 in their place. Because these 5 recommendations have come from what? It has come from the rule. You are required to recommend 5. Something like that.
lawsuit, that situation.
No,
This situation has already gone low. So far, lawsuit peeling up from other lawsuit. Those who are in the next merit lawsuit.
okay.
To my understanding, the situation already gone low.
Anyway, let us.
Because
I was.
we are lawsuit intending not to recommend him lawsuit because of change of circumstance law. This circumstance was not there when this selective were recommended to the concerned department also. Just we may be given liberty to take a decision. And in view of the order passed by this court, we cannot take that decision. This is our difficulty.
What was the direction for recommendation? 5 candidates from select list
Order
have come from where? Because there was a select list of 5. No, it's not like
waiting
this.
list.
No, it's not. If I remember correctly,
Closed.
you point out if it is incorrect. You are supposed to recommend as many numbers
they were only the persons who were kept in the waiting list lawsuit.
See, list is perennial.
This correct lawsuit. These are the 5 persons who were kept in the waiting list lawsuit.
So therefore, let us hear them. Tapin.
So this judgment was passed in their action lawsuit.
So see, now this.
And they have
see,
not come before the authority also.
they may not be aware of this. See, they were not a party to this writ petition.
Correct.
After the judgment was passed, some rights have accrued to them. Now you want to deny them. You may be justified in denying them, but they will have to be heard now. Like those 3 recommended who are now working,
Lawsuit,
they were not a party to the writ petition.
lawsuit, another 2 has to be picked up. The next to the merit, next on merit lawsuit. That issue is was something different lawsuit.
And I don't know.
We are all lawsuit, whether this person can be lawsuit recommended or not lawsuit, Delhi Roja. Only that's the issue to be decided by the donor court lawsuit. No, the others who have, whether they are to be kept in the waiting list, if they are deleted. That issue is not here in this case.
So let us deliberate on that. Let them appear. Since if we pass order in their absence, the right accrued to them we are taking away. We have to hear them.
Yes, I'm praying
See,
because lawsuit-
issue in that writ petition was also not whether additional recommendation should be done or not. Court took it up so much.
because they were in the waiting list lawsuit. They
Ah.
were in the waiting list, therefore it was direction was given by this court. lawsuit.
So these 2 persons are also in the waiting list.
Correct lawsuit.
Then
Because of change of circumstances.
what is the change of circumstances?
Because criminal case is pending against this.
You are not the appointing authority, mister.
Lawsuit, therefore I have placed the judgment lawsuit.
So therefore we will hear them.
Lawsuit then.
They will also bring with the
Lawsuit,
judgment.
then-
They will also bring the judgment. We'll consider the judgment. But how can you deny them the opportunity to hear it?
lawsuit.
Mr. S. Senior Government Advocate. Issue notice, returnable in 4 weeks. These steps were registered posted every as well as by usual process within a week. You some notice on this director streams also.
Lawsuit notice has to be served to the Delhi Roja only. Otherwise, rest are, they are not going to include this.
No, what about this Nirvay Singh?
Nirvay Singh lawsuit, he has no boss lawsuit, apparently on a record lawsuit.
We'll hear him. You'll, okay, issue notice to the respondents 1, 2, 3, 4, 5, 6. By registered post with area as well as by user process. Listed after 4 weeks.
Lawsuit, in respect of private respondent only. Notice is in respect of private respondent.
Then how you will serve this other other respondents?
Other respondent lawsuit,
Director
from the facts of the case lawsuit,
streams.
it's not disputed. Posts are
See,
laying against
Mr.
them.
Mr. Once you have made a party,
Lawsuit.
whether they will be affected, not affected, they will have to be served notice. Then first of all, why have you brought them here?
Because they are party in the lawsuit, read petition.
Yes. See, making a party is your choice. If you want to struck up, well, you may struck it up. But since you have made it.
Just I'm appraising laws, this on court lawsuits. Since they are not going to be affected lawsuit. And their case is not disputed here lawsuit. So therefore I'm just praying lawsuit. Otherwise, notice may be issued.
Though Mr. Tapin, so just a minute. Issue notice returnable in 4 weeks. Though Mr. Tapin Lanasingam has submitted that notice to the respondent number 1 only be required. As there is no post for the respondent number 2 and the respondent number 3, 4, 5 and 6 would not be affected if the review petition is heard and if the review petition is heard and disposal. Yet, since the petitioner has made as many as six respondents in the instant review petition, notice to all the respondents are required to be issued, for which the petitioner shall take steps for service of notice upon all the respondents were registered post with AD as well as by use of process within a week. So that clarifies.
Lordship. And this lawsuit matter was moved for first time in August 2022 lawsuit.
Doesn't matter.
Notice was not issued at that point of time.
Ah.
Anyway, no problem.
Yes,
My lord, I beg to mention item number 19. I just missed the matter, my lord. I
Ah.
was at session court, my lord. My appearance may be, my lord, reflected, my lord. Petitioner, I'm petitioner, my lord.
yes, what do you say?
Item number 19, my lord.
Yes.
Matter is just over, my lord.
Ah.
My appearance.
Oh, your appearance may be.
Yes.
Okay, all right. L could for petitioner in 19. Okay,
And my lord, there was status quo was here, my lord.
we have extended it while you are in the sessions court.
My lord.
Okay.
Deeply honoured, sir.
Item 4. Okay.
Possible, ma'am.
Hmm.
My lord, in this case, my simple case of the petitioner is that earlier there was a post of DLRSO, sorry, District Land Revenue Settlement Officer. That was taken up to be filled by DPC. At that point of time, I was selected and the post was declared to be a reserve post. Thereafter, Lordship, that was another person had Lordship challenged that promotion, that DPC, and then it was quashed by this honorable court, but not on the ground that it was a reserve or unreserved post, but on other grounds. Now, because of that, a fresh DPC was held. In the fresh DPC, that very same post was again declared to be unreserved, and the private respondent was recommended. That is the only case, Lordship. So if the post is a reserve post, how it morphed into an unreserved post, that is for them to Lordship answer.
Yes. Affidavit is filed.
Yes, Lordship.
How have they answered?
They have said that as part of the roster, that is unreserved post.
Hmm.
The roster is the same since the first DPC also. So how they have come to that conclusion that they will have to explain also.
Yes. No, just a moment. You are challenging the DPC
Yes.
13/11/2017. What is that? What is this 9th March order? Oh, that must be promotion order.
Yes. That was promotion.
Yeah, where is this DPC? 13/11/2017.
13/11, page 44.
Yes, 44.
Start, Lordship, sorry, Lordship, this is not page 44. This is the DPC is page 46. Lordship. The question DPC,
46.
46.
Page 8, para 12 is their answer. Motion of the affidavit in opposition filed by 1, 2, and 3. Your lordship may also see page 33. Oh, sorry, page 35.
You were promoted as the other as well.
Yes, by DPC dated 23/10/2015. That is it, page
2310
2015.
15.
Yeah, DPC
Two-
dated.
two-
I'm lordship.
Okay, 2015. That was
Yes.
the DPC.
Yes, there was a DPC in which this very post was declared to be a reserve post, and that is why I was given promotion. But that was, of course, set aside by this honorable court on different grounds.
On what ground?
On the ground that promotion was not a regular promotion because I had not reached that 15 years at that point of time.
Okay.
And also that that post ought to have been filled up by the old rules, because by that time the rules were amended. Lordship will see the honorable court's order, page 38.
Okay.
But I'm only concerned with that the post at that time in the DPC was held to be a reserve post.
As per column 12 of the rule.
Yes.
Recruitment rule is 2006.
Yes, the
Okay.
relevant recruitment rule for this post.
As per
Otherwise, it has been amended in 2015.
2015,
Yes,
it has been amended.
yes,
Then unamended rule is 2006.
yes.
And this DPC was held when? 2017.
Yes, 13/11/2017. Lordship, because there is a lot of facts here, so it seems confusing, but the meat of the matter is only that, Lordship. First, DPC was held 2015, saying this post was reserved, so therefore I was recommended. It was set aside on different grounds. Then again, because of that, the second DPC was held. In the second DPC, the same very post, they are saying it is unreserved, and therefore they have recommended the name of the private respondent.
Okay. Where is the answer?
That is page 8 of their affidavit of opposition filed by respondent 1, 2, and 3. Page 8, para 12.
1, 2, and 3.
If this was the case, this should have been the case in 2015 also. So we don't know whether how this came into being. Page
Paragraph
12.
12,
Yes. Of
page
the
8.
yes, page 8.
Yes. Yes, who appeal for the government?
I'll be appearing for the government there.
Ah.
Because it says the affidavit. Because prior to my appointment as a executive officer.
Ah.
In case better since it has been prepared by the government at that point of time.
Ah.
So I will request my friend to address the court on this. Otherwise, also. Well, on the issue there, earlier, there was a 206 recruitment. Code. 2006. I use it. 2006. And another that was amended and another was brought in the 2015. So this was the vacancy arose in the
2012.
yes. Therefore, there are which is body the field was 2006 RR. As per that RR, the eligibility criteria is given. And it is the respondent who was qualified at the point of time. Private hospital.
Private respondent was qualified.
Yes.
When?
Was qualified in the year 2012.
Well.
When this post
Okay.
he was only qualified. So he was rightfully by this DPC of 2007 and rightfully followed.
No, is this post a reserve post or?
Yes, we are saying that it is a reserve. Sorry, no, unreserved. Was stated to this post, single post which were this vacant in 2012 is general for general.
Where is the DPC minutes? when this petitioner was promoted on officiating basis?
This is page 35. Page 35 of my written petition.
So this, in this DPC, you appear to have said this post is reserved for APST. At page 36. At page 36. There is only one vacancy under promotional quota of JLR SO, and the post is reserved for APST candidate.
This DPC laws, it was going to challenge why we are filing
Yes, but not on those grounds, on different grounds.
petition number 17
Yes,
of 2006.
in that writ petition, was it said that this post is not reserved for APST?
No,
That was not the issue, Lordship.
that was not the issue.
Then that has no relevance, I think.
Why this judgment? First in this repetition, at Terana, it had been directed by this Supreme Court to hold fresh DPC, inviting all the qualified candidates. Now, later on, although notice, it can be seen from the DPC of 2017, although in the year 2015, when this notification DPC was published, it has been said that it is a reserve, but later on, our authority, after thorough verification of the report, after found that this is unreserved. Therefore, this is unreserved. Therefore, this vacant post, which was called vacant in the year 2012, it was declared unreserved. And accordingly, this gentleman, respondent number 4, he was in the senior SK in the department. So he was.
No, it's not a question of senior junior. It's a question, the respondent 4 is non APST.
No,
Oh, APST.
no, not APST. Not APST.
No,
Non APST. So
I would like to make some explanation regarding this reserve and unreserved lordship. Lordship will come to my affidavit last page, 33, page
no,
33.
has Mr. Kamru completed?
First, yes.
On this count only, lordship, because he will be doing the case. The land is standing council is.
Yes,
Mr.
yes.
Kamru, lordship.
Affidavit
only.
means, affidavit means?
The affidavit which 1 to 3,
Yes,
which I have filed, lordship.
paragraph 12.
No, lordship, page 33, last page.
Okay.
My,
That- That is affidavit by respondent 1, 2, and 3.
1, 2, and 3.
Yes.
Here lordship will see. Post-based roster 0.4 post of DLR and SO, lordship. Here lordship
Just a
will see
moment, page 30,
3,
33, yes.
the last, yeah. Yes.
Yes,
Here lordship will see promotions based on roster.
1, 2, 3, 4, 5 unreserved lordship. This is. But then in the unreserved is a reserved category person is here, Sri Pumet Banyan, utilized by APST, transferred to reserve point lordship. And then this is carried forward to this serial number 9 lordship,
Yes.
unreserved carried forward lordship.
Ah.
Yes, sir. That's why in this reserve, the respondent number 4 has been lordship appointed.
Respondent number 4 is also a reserve candidate, APST candidate.
Non-APST candidate,
Oh,
private respondent number 4 lordship.
That is what I'm saying.
Yes.
It's a non-APST.
Non-APST,
So it has become no unreserved.
unreserved. In
Un-
reserve, in earlier unreserved, APST is there lordship. A lordship can see in the 5
Though it was unreserved,
unreserved,
it was filled up by APST candidate.
yes. So is being carried forward lordship.
As what? Unreserved post.
Yes. In
Okay.
reserve, so unreserved is being filled now.
In- In
8 bar roster best point.
unreserved post, APST can also compete. APST can also be considered.
Lordship, because this is promotion method,
Uh,
lordship, promotion.
uh,
In lordship, examinations, lordship, competitions, lordship is APST can also compete, but then because this is reservation, promotion.
Promotion.
Unreserved will be given to the APST only, non-APST only, lordship. Yes. This is roster based, lordship.
So it is reserved for non-APST then.
Lordship, because in reserve system, just a second, in the roster point lordship is 1, 2, 3, 4 lordship is reserved, and then 5 is unreserved.
Unreserved means in
Is it-
where APST candidate cannot be considered for that post.
Lordship,
Only the non-APST will be considered, something like that.
yes, lordship.
If it is so, you can't say it is unreserved. That is also reserved for non-APST.
But then here lordship usually use what is.
But if you say unreserved, that means it is reserved for nobody, neither APST nor non-APST, open to all.
Unreserved, lordship. This is
Unreserved.
because this is a roster based promotion, lordship.
Ah.
They cannot, otherwise, lordship, non-APST won't be getting any lordship slot that way. Already 4 post is for APST, for 1, 2, 3, 4, and
Then why this is contradicting the earlier finding of the DPC head, earlier DPC, where you have recorded that that post is reserved for APSC candidate. It was in that post, this petitioner appears to have been promoted on officiating basis, which was challenged, that he does not fulfill the eligibility criteria and set aside by
yes,
that ground.
years of service criteria.
So why this change of a post? That is the petitioner is asking. Earlier you have said it is a reserved post. How it has become unreserved?
Lordship, when finally DPC is being seated, that was for not for promotion, lordship, that was for ad hoc promotion. So at that point of time, maybe no.
But the post remains the same,
Post,
is not it?
lordship.
The seat, the post which now is under occupation of the private respondent
Lordship.
is the same post where petitioner was at one point of time promoted,
Yes, lordship.
and that was found to be a reserved post.
It was lordship.
Then how it has become
This way,
unreserved?
lordship, this explanation regarding. this,
Carry
lordship.
forward.
Carry forward, lordship.
If you carry forward, the reserve post become unreserved.
Lordship, it is being done for the reserve also and then unreserved also. Otherwise, lordship, non-APST they will never have any slot in the promotion portal, lordship. Even in this lordship, from 1 to this this one only is non-FST, all are FST. 8 for 80-20 also lordship.
Yes, June.
I leave it to the main council lordship.
Each issue need to be determined from the perspective of occupied field, that is 2006 recruitment rule. Now, Malone has seen that 2012, the post of DLR also was created. The government of Arunachal, they follows 100-point roster. Now this 100-point roster base, Malone, it is like this. The reservation is, suppose the example would be 10 posts. 4 posts would be reserved for the APST, and the 5th post is for the non-APST. Now, in that even also, if there is no writing candidate for the non-APST to be promoted on that particular point, government carry forward it. And the officers ripened for promotion is filled up. Then again it goes, to 6, 7, up to 8. Then last 2 posts would be reserved for the non-APST. So this is 100-point roster, how it is implemented in others. In the instant case, I'll demonstrate from my affidavit, annexure 1 series, page 1 to 13, that is combined seniority list. Well, before that, let me place the recruitment rule. Malone will come at page 9. Page 9 is the recruitment rule dated 10 October 2006, notified me. Now in the schedule, it says schedule 11, 50% by promotion and 50% by direct APSs. Now from the column 12, Malone will find by promotion from amongst the plain table, surveyor, recorder, Kanungo, supervisor Kanungo of the department who have rendered 8 years of regular service in the grade and possessing the following. And these categories. And by this particular point of time, the petitioner was not eligible. Now, kindly see 19/9/2012. Seniority list at page 13. This is the combined seniority list of survey staff of land management department 13/5/2012. Now next page, my lord, will come. Surveyor of Kanungo at page 14. I stands at serial number 4. And the petitioner stands at serial number 6. He was not eligible by that point of time. So therefore, the field that was occupying was the 2006 and this seniority list. Thereafter, what had happened was One Rana Gudong. I think page 38, which is page 30 of 38 of the rate petition. I think they have also annexed. Page 38. Huh? No. My lord will see page 20 of the affidavit in opposition filed by the state respondent.
Yes.
The issue was put into challenge. Person there too. That was for post of that's based on the district dynamic 2012 settlement and group B recruitment rules for considerations of holding DPC. Then this was preceded by where is this mission? Okay, well, kindly have the repetition for that. Yes, page 20 Miller.
Yes.
It is order dated 11/6/2015, page 2022. It was put into challenge. When the finding was Malad will come at page 23.
Yes.
It has been submitted by Mr. Mao, learned counsel for the petitioner, that the petitioner is the senior most SK among the grievance supervisor Alongo in terms of final combined seniority list of service staff in the Department of the Land Management, Government of Arunachal Pradesh, as on so and so date. Now, next paragraph says the petitioner, through the help of so and so, post of DRSO in the department concerned was held on 03/12/2006 and presently 3/4 of DRSO are lying vacant in the Department of Land Management. Now the situation must have changed, Lord. Just I'm indicating this. Now the finding, my lord, will come at page 24, last paragraph. Upon hearing the learned counsel appearing for the parties at length, in the interest of justice, it is hereby directed that the read petitioner, namely so and so, shall submit a press representation before the respondent number so and so, Commissioner so and so, Arunachal Pradesh, narrating all his grievances on and before 5th June, along with certified copy of this, the last one. In the event of submission of such representation of the petitioner, if press, the says respondent number 2, Commissioner, Department of Government shall dispose of the same by passing a reasoned and speaking order within a period of 60 days. This was the first one direction. And thereafter, will kindly come to page 26 itself. This was the ground for ground. The reasons they have given. Para 5 is important here. Page 26. In so far, vacancy of DLRSO and post of department is concerned, the petitioner is aware of the fair.
All right. We'll continue next week.
Fine.
Uh, 16, 17? Date fix?
What means,
Or we'll say next week, after a week.
after
Council for the party, this is after a week.
no petitioner. No. One. Yeah, right.
Simple उन्हें किसी को क्या क्या बोलना इतनी पकार अब लोग का किताब नहीं वो नहीं ये तो ठीक ही है हो जाएगा हमको भी लेकिन चिंता नहीं क्योंकि यार ये रिटायर हो गया हो गया क्या एक तो कल होगा ही अभी वो कौन रिटायर हो गया इंटेलिजेंस जो रिटायर हो गया तब तो कुछ नहीं है
In this case, on 3rd January 2020, the Learned Senior Council had briefed before this honorable court that a criminal proceeding is going on before the trial court with respect to the petitioner who was suspended from his services because of a POCSO case that was registered against him. And it was asked before this honorable court to list the matter only after the criminal trial was over and the criminal proceeding is still continuing and it is at the stage of evidence. Hence, this matter may be fixed after the criminal proceedings are over before the trial court.
What have you challenged here?
Out here, the petitioner is challenging the dismissal order of the department.
Dismissal order of
Yes, he
department.
was suspended from his service as a constable.
Then if you are acquitted there, then what? If you are acquitted in the trial, then what happens?
Then he should be discharged of his charges in this departmental proceeding as well. Because the submission of the petitioner is that it has not been done in accordance with the existing statute. Although I'm not aware of it in detail, but there's an order of this honorable court.
Is it the position, Mr. Tapin?
If Lordship see that Captain Anthony's Anthony's case was out of same sets of facts law, using the same Lordship evidence are equal and same laws. And if two proceedings are pending, then criminal department proceeding to wait till the criminal proceeding is and unnecessary delay is their lawsuit. Then department proceeding can go ahead.
The here department
here also-
proceeding has been concluded.
Already concluded lawsuit. There's no point of lawsuit.
Yes,
It was appealed twice already, and then we have referred this petition against the decision of the department.
see. Dismissal order is for what? You are arrested, that's why.
Because we were arrested, I was arrested, and also because the case was registered under the POCSO Act.
Okay. So you are yet to be convicted.
Yet to be convicted. It is at the stage of evidence. The IO is yet to be examined before the trial court. It is almost over.
Writ petition is of 2014.
Yes, sir.
All right. If the trial court acquits you, then according to you, this writ petition should be allowed by setting aside your dismissal order.
You know, I am not.
See, perhaps that is for this purpose, I think the council is saying that let this matter be taken up after the
I believe so.
Trial is concluded. Is not it, Tapin?
It's
Suppose you were acquitted. Then what? You automatically entitled for a reinstatement after
Yes,
setting
Your
aside.
Yes, Your Honor, because he'll be washed away of the charges that was levied on him.
Then what happens? The victim or the estate prepares an appeal before the High Court. And High Court set aside the acquittal order.
Then the result will be something else, Your Honor. That
Huh?
depends on the future.
Then there is yet another court. Supreme Court. Then what happens? I don't know whether it is the law. See, this writ petition was filed 2014 and you are still waiting for. It is a POCSO trial.
Yes, Your Honor.
Why it is taking such a long time?
Because the IO is not appearing.
IO is
They've
not
sent-
appearing.
They've sent out warrants also, but then apparently the IO has already retired and he is not.
You are on
residing.
bail.
He's on bail. Only the statement of the IO is left. Rest of the
Case-
witnesses have already.
The trial began when?
I'm not aware of that. Must have started 2-3 years back already.
UPI.
Oh, trial is at UPI court out here in sessions.
UPI.
Yes.
What is going on? POCSO case are to be completed within 2 months, I think.
They are still waiting for the deposition of the IO. IO has not been examined yet.
otherwise may have pre laws. This matter may be taken out tomorrow. Let
Senior counsel.
Parties are maybe let him appear. So let's examine tomorrow.
What according to you is the position?
Trial is concerned lawsuit. It's now with
No, not the status of not the stage of the POCSO case. But should this writ petition wait for the conclusion of the trial?
Therefore, lawsuit just they were submitting with it.
Uh.
Let the matter come up tomorrow lawsuit.
Good.
It may be examined lawsuit, whether we can proceed or not. Otherwise, unnecessarily this being lawsuit delayed.
Yes,
I'm not praising because it's not late.
Yes, Your Honor. I will not be in a better position to answer.
Tomorrow lawsuit.
next week.
Just to see if we can proceed lawsuit.
Huh?
Just to examine if we can proceed lawsuit.
For that also, next week we will open.
No,
Huh?
Next week.
Can you fix a date?
That can be.
17th or 16th?
I cannot say because I do not have the dates of my senior.
Who will have his date? Okay.
17.
On the council for the parties. We'll say listed after a week.
No issue.
Obliged to.
Well, lordship, is a matter of the government quarter allotment.
You have been allotted.
Yes. Your lordship, here only one issues. That is quarter is either agriculture department quarter is under the purview of the deputy commissioner. That's only here issues. May that they go in detail. The petitioner is this petitioner was working as fathers, working as driver under agriculture department and allotted the government state government quarter fishery colony SEPA by deputy commissioner allotted by the deputy commissioner SEPA. And the petitioner also grown up at the aforesaid quarter. That in the year 2013, the petitioner was appointed as WC mate under PHC SEPA division. Even then, petitioner reside with his father at aforesaid quarter like a joint family.
Because the petitioner has not having any land or building at Sepa town for accommodation. Therefore, the petitioner applied his father's government quarter for accommodation before retirement date. To the petitioner, why so and so, and allotment is given to the petitioners. Page 10. This is the allotment. Page 10, Annex 1. This is the allotment. May under so and so, FR so and so, so and so.
Where is the cancellation order?
No, this is the allotment order.
Where is the cancellation order?
There is two cancellation orders here.
Oh.
One cancellation order is page 13. This is the first cancellation order. Again, this cancellation order is recalled page 16. Again, this thereafter again cancel on page 18. Page 18. Order of the 2nd April 2018. Then we have come this before the Supreme Court.
You are in which department?
PhD department.
PHE.
PhD.
Is Khalasi?
And the WCP.
WC.
Yes, WCP. Para team.
So the quarter belongs to agriculture department.
Your lordship, water is agriculture department. But here you also except department forest and the police. All the departments belong to under a general pool. That is allotted by the deputy commissioners.
Okay. Agriculture department has no separate quarters.
No separate quarter.
Where have you stated?
Though it may be quarter is they belong to the agriculture department and the fishery department, any other department, except police and forest.
Which paragraph you have stated?
Para 5.
Para 5.
Yes. On 17/2000, the petitioner was submitted representation before the deputy commissioner for reconsider after first cancellation order. Revoking the cancellation order because the aforesaid government quarter come under EA pool. And the aforesaid quarter was first occupant was working under the agriculture department and that was also allotted by the EA. That quarter was earlier also allotted by the EA. That is deputy commissioner.
Okay. What is the answer to this?
Your receipt.
What is the answer to this in the affidavit file?
Your Lordship, we have stated that it was a mistake on our part and we have rectified our error. Page number 4, Your Lordship, paragraph 6 of our affidavit. Your Lordship, it starts from page number 3, last. That with regards to statement made in paragraph 4 of the writ petition, state that after allotment of quarter to so and so on condition as stated at paragraph 2 above, a letter by so and so dated so and so received from the DAO District Agriculture Office SEPA whereby it was informed that the said quarter belongs to Agriculture Department and requested a BC SEPA to cancel the allotment order.
Yes, sir.
There is a stay order.
Yes, sir.
You produce the record to indicate that agriculture department in SEPA or for that matter in SEPA has how many quarters? Huh?
Your Lordship, interesting case is here. Paras page 16. Your Lordship.
Page 16 of affidavit in opposition.
This is the second allotment order, sir. Recall the first cancellation order. Page 16 here. Kindly see. There is the respondent is alleged that there is oversight. There is no oversight here. Kindly see the page 15, first cancellation order. That- Page 13. This is the first cancellation order. Second paragraph. However, it is been learned that the quarter actually belonged to the agriculture department and was allotted to you by oversight.
Just a moment. Page 16,
Page 13.
13.
Page 13.
First cancellation order.
Yes, first cancellation order, second paragraph. However, it has been learned that the quarter actually belonged to the agriculture department and was allotted to you by oversight.
Okay.
Hence, the earlier allotment order so and so and so and so is hereby cancelled with immediate effect. Again, after repetition, that is page 16 here. Third paragraph. Mary. Whereas as per the record available in this office, all the quarters except forest and police department are being allotted by the district administration on conventional basis, including from the past practice of the district. And whereas the aforesaid quarter number so and so under agriculture department is very much under ambit to allot by the deputy commissioner East Coming district SEPA. Therefore, the earlier quarter allotment order issued to one Ram Jamo, that is petitioner, do hereby stand.
Just a moment. See, Mr. Iram.
And your lordship, copy to your respond for copy to 4.
If this quarter is of the agriculture department, why it has been allotted by the circle officer or the deputy commissioner? It should be at the disposal of the agriculture department.
Yeah. Forwarded your lordship, I need further instructions, your lordship.
And that order could be.
All right, had Mr. Gyadi T. Gyalani counsel for the petitioner and Mr. Vairera, learned government advocate. Where is the impugned order? Page 18.
Yes.
The order put to challenge in this writ petition is dated 2nd April 2018, issued by the circle officer. Accommodation. ACCOM is accommodation.
Yes, accommodation.
Okay, circle officer accommodation for deputy commissioner East Coming district SEPA by number sense at page 18, whereby the government quarter number B-29 type 2 at fishery office SEPA allotted to the petitioner who is working as a work charge employee in the department of PHE has been cancelled on the ground that the quarter actually belongs to the agriculture department. Challenging the opposite cancellation order dated 2nd April 2018, the petitioner has contended that agriculture department does not have any government quarters of its own in the district of East Coming at SEPA. Isn't it? To which contention raised by the petitioner in the writ petition, it has been answered by the respondents in the counter affidavit filed by the respondent number 3. That after receipt of a letter from the district agriculture officer SEPA, it has been learned that the quarter belongs to agriculture department and the same was under occupation of the staff of agriculture department. And hence and hence the allotment order of the quarter issued to the petitioner has been cancelled. The respondent number 3 in the counter affidavit file, however, has not substantiated with any evidence to prove that the quarter in question actually belongs to the Department of Agriculture. First, in view of the above, let the record indicating as to how many government quarters the Department of Agriculture has in the district of East Kame, more particularly in Sepa, no? Be produced from the respondent authorities by the learned government advocate. First, to enable Mr. Lira to do the needful, list it after 4 weeks.
Lordship, last time records were called for, whether those records are before your Lordship or not?
Record pertaining to what? Sarva Shiksha teacher. Okay. What for the record was called? To
Record was called as because this is a question of conduct of examination. I was an invigilator among 60 other invigilators, one among 60 other 80 other invigilators. Now, in their affidavit, they say that clear instructions were given in written as well as verbally not to take out unused question papers from the examination hall even after examination is over. So that instruction, that record was required.
what is your dismissal?
Another record required was, we say that we were not furnished with, served with SOCOS notice for termination. We said that. Now, Pion book was called for. They say that.
Where is your dismissal order?
Lordship. Last page of my petition, page 27. This is like a letter to his own friend. Order dated 13/6/2018. Your Lordship will mark one thing here. In no number DCP SD Judicial 01-2016-17, then 204. This number is here. But the document which they have annexed as SOCOS notice, this number is not there. To my understanding, in official letter, in official memo number is to be there, has to be there, and official letter number has to be there. As because I say that this is a purported document which was never shown to us. Now order says, this has the reference of earlier order number so-and-so, dated so-and-so, 10/6/2018. As per the order number cited above, you were suspended from the government service for indulging in paper leakage allegation case During the recruitment examination for the post of UDC, LDC, and MTS held under the establishment of the Deputy Commissioner, Siang District, Pangin, till completion of the inquiry. And after thorough inquiry of the case, the facts has been unearthed, and you are found to be prime accused in the case. Whereas such act of violation of conduct rules of government service by a contractual government employee is improper and unbecoming and invites disciplinary action as per CCS rule. Hence, taking strict note of her being the prime accused and violation of government rules, the contractual service of Srimati Amoti Karpuk Jeti Sarva Shiksha Abhiyan is hereby dismissed. This order supersedes earlier suspension order so and so dated 10/4/2018. So this is an order, shortcut order, which has not followed the laid down CCS rules. At least there has to be inquiry, then allegations, then reply. So many things are there. So that has been all thrown away, and he has just concluded with this. So we are challenging this. He is also writing only leakage, allegation of leakage. There was no leakage. Allegation of leakage. And it's a major penalty. Dismissal is a major penalty. After serving the state for more than 10 years, I've served for 11 years continuous.
Deputy Commissioner has filed affidavit.
Yes, Sir Lordship. We have filed our counter affidavit.
How have you described the legal status of the petitioner's service?
Your Lordship, from our affidavit, Your Lordship.
Huh?
From our affidavit, Your Lordship, the petitioner has admitted that during the investigation.
No. Before that, petitioner was still in service when order of dismissal dated 13/6/2018 was issued.
Yes, Sir Lordship. Yes, sir. He was,
Huh?
yes, sir. He was in the service.
Yes, let
That's
us
why-
see, let us see the affidavit of the Deputy Commissioner. Are you aware of direction of this court to file affidavit by the Deputy Commissioner?
there was five and instruction was given to me.
Ah.
Accordingly, I made over the direction was given to them.
Ah.
They filed minor.
They
They filed.
filed by the deputy commissioner.
Yes, sir. Filed by the deputy commissioner. It is additional affidavit minor. This is affidavit of it. This one is says, filed on 4 January 2029. After your lordship given the order.
Ah.
4 January 2021.
Deputy commissioner has filed.
Deputy commissioner has filed the affidavit.
Which respondent, deputy commissioner?
Respondent number 3.
I can see one affidavit of Puvi Pangu.
Yes, sir.
Puvi Pangu had filed affidavit.
Yes, sir, Lordship.
Why?
Additional affidavit, your Lordship.
Why?
This one on 4th of January, your Lordship, 2021.
Why it was filed?
Your lordship, it was simply filing of record.
Okay,
It was simply filing of record.
just a moment. I have not been able to locate the affidavit of deputy commissioner. Respondent number 3. 3 is the deputy commissioner.
Yes.
For the Jalan, circle officer. Yes, what is that reference to? Order of this court dated 19/3/2021 in the affidavit.
It's a legal status of the petition.
Where? Which paragraph?
This paragraph number
1, your Lordship.
1.
Paragraph number 1.
Page 2, your Lordship.
Yes,
Yeah,
yes.
this honorable court, by order.
No. Then I am not interested. Affidavit, that will be additional affidavit file. Yes, Nicola, additional affidavit, yes.
Actually, this was the craft of the letter before this coming into the marriage minor.
This is the Puvi Pangu.
Yes, sir, Lordship. I have filed, your Lordship.
Deputy commissioner was directed to file affidavit.
Yes, sir. Lordship.
How can you file?
My lord, this was instruction was given minor, instruction filed.
Legal
Then
status.
why any officer from the department shall come for filing of a counter affidavit? It shall be filed by all the government advocates. If a government advocate can be authorized, no officer from the education department is required to come to the court. You will sign all the affidavits. Yes.
We will make one officer to this file is important. We will submit communication to the commissioner. To the this file record. File record.
Thank you.
Oh, I think it. In that aspect, Lordship, we have filed RTI and we have annexed the last salary drawn from office.
Just a moment.
So.
No, it was, see, it was not having regard to not only in your case.
Okay.
Just the court wanted to know,
Lordship.
such order was passed in some other case also. Once you appointed for a year, you continue indefinitely. It was in that context. But how could you file an affidavit, Ms. Pangu?
Your Lordship, direction was given
By whom?
by the Honorable Court, Your Lordship, to file additional affidavit.
To Ms. Puvi Pangu?
Yes, sir.
Huh?
Letter status of the petitioner, Your Lordship.
Which order? Please read.
Your Lordship, 19/3/2021, Your Lordship.
19/3/2000. Do you have the copy of the order?
Your Lordship,
Okay, just-
Jot it down here.
Just point out from the order where Puvi Pangu has been directed to file an affidavit. Because this is something very unique, which we have come across. I have not seen any government advocate filing an affidavit.
Here was right to proceed to file an additional expressing the legal status of petitioner. In the post of junior SSA contract. As I noted down in the file. The direction was not given to me, direction was given to Deputy Commissioner, Your Lordship.
Just